Appeals Court blocks indiscriminate immigration sweeps in Southern California. A recent court decision has thrown a wrench into the Trump administration's immigration enforcement strategies, protecting communities across Southern California from sweeping appearance-based raids. This ruling isn't just a legal technicality. It's a lifeline for families who've lived in fear for months. The Ninth U.S. Circuit Court of Appeals recently upheld a temporary order blocking immigration agents from conducting random stops and arrests in 7 counties, including Los Angeles. But here's where it gets controversial. The administration is already preparing to fight this all the way to the Supreme Court, raising questions about the limits of executive power and the rights of immigrants. Mayor Karen Bass called the decision a significant win for our city, emphasizing that the courts finally recognized the harm caused by targeting people based on their accent, neighborhood, or workplace. Since the order was put in place, we've seen a return to calm, she noted, pointing to the visible tension that had gripped communities since June, when arrests at car washes and Home Depot parking lots spiked. The temporary restraining order, issued last month, bars immigration agents from relying on factors like race, ethnicity, or location alone to justify detentions. For example, someone simply waiting at a bus stop or working at a car wash can't be stopped without reasonable suspicion of wrongdoing, a legal standard the administration has yet to meet. A 90-minute hearing in San Francisco highlighted the clash over this issue, with the Trump team arguing that Judge Mame Ewusi-Mensah Frimpong's ruling overreaches. The lawsuit driving this battle was filed by Southland residents, workers, and advocacy groups, who accuse the Department of Homeland Security of running a program that abducts and disappears people through unlawful tactics. Mohammed Tazar of the ACLU Foundation of Southern California called the court's decision a confirmation that these raids violated the Constitution, adding that the damage to communities has been irreparable. But the fight isn't over. Bass predicts the administration will escalate the case to the Supreme Court, where the stakes could not be higher. Meanwhile, Latino and immigrant families in Southern California remain on edge, having endured months of anxiety as enforcement operations targeted everyday spaces like businesses and immigration courts. So where do you stand? Is the Trump administration's immigration strategy a necessary security measure or a violation of civil liberties? Share your thoughts below. And this is the part most people miss. The legal battle isn't just about enforcement tactics. It's about who gets to define the boundaries of freedom in America. Federal court blocks ICE raids in Southern California. Constitution rulings explained. Imagine being pulled over simply because of the color of your skin or the way you speak. That's the reality some Southern Californians face under the Trump administration's aggressive immigration policies. But here's where it gets controversial. A federal appeals court recently ruled to uphold a temporary order blocking these indiscriminate immigration stops and arrests in Southern California. The Ninth U.S. Circuit Court of Appeals held a hearing where the federal government tried to overturn the restraining order, arguing that it interfered with their enforcement of immigration law. Immigrant advocacy groups, however, took the administration to court, claiming that it was targeting brown-skinned individuals in Southern California during the crackdown on illegal immigration. The lawsuit included not only immigrants without legal status, but also 2 U.S. citizens as plaintiffs. In her ruling, Judge Mame E. Frimpong stated that there was a mountain of evidence that federal immigration enforcement tactics were violating the Constitution. She emphasized that race, ethnicity, language, location, and occupation could not be the sole basis for reasonable suspicion to detain someone. The Los Angeles region became a battleground, with protests and even the deployment of the National Guard and Marines. Federal agents conducted sweeps, rounding up immigrants without legal status from Home Depots, car washes, bus stops, and farms, many of whom had lived in the U.S. for decades. Among the plaintiffs was Los Angeles resident Brian Gavidia, who was shown in a video being seized by federal agents while yelling, "I was born here in the States, East LA bro." The American Civil Liberties Union, ACLU, attorney Mohammed Tajer argued in court that the government's actions were unacceptable. The federal government countered, arguing that they hadn't been given enough time to collect and present evidence in the lawsuit. They also claimed that the lower court's order was too broad and that immigrant advocates hadn't provided enough evidence to prove that there was an official policy of stopping people without reasonable suspicion. However, the judges sharply questioned the government's arguments. Judge Jennifer Sung, a Biden appointee, noted that while considering factors like race and language is not illegal, they alone cannot form a reasonable suspicion to detain someone. In a city like Los Angeles, where Latinos make up nearly half the population, these factors cannot possibly distinguish between documented and undocumented individuals. And this is the part most people miss. What is the harm in telling federal agencies not to do something they claim they're not doing? Los Angeles Mayor Karen Bass celebrated the decision, calling it a victory for the rule of law. However, she emphasized that the fight for justice must continue, as the city stands against the administration's efforts to break up families who contribute to the life, culture, and economy of Los Angeles. So, what do you think? Is this a necessary step to protect civil liberties, or is it an overreach that hinders law enforcement? Let's discuss in the comments. Ninth Circuit ruling, a major setback for ICE patrols in Southern California. A significant setback for immigration enforcement in Southern California. The Ninth U.S. Circuit Court of Appeals delivered a powerful rebuke to the Trump administration's aggressive deportation strategy on Friday night. In a passionate ruling, the court upheld a lower court's decision to block the implementation of roving patrols that had been planned across a large portion of Southern California. The panel stated, if, as the defendants claim, they are not conducting stops without reasonable suspicion, they cannot argue that they are suffering irreparable harm from an injunction that seeks to prevent a specific type of stop that lacks reasonable suspicion. This ruling maintains a temporary restraining order that prevents heavily armed agents from detaining individuals on the streets of Southern California without first demonstrating reasonable suspicion that they are unlawfully present in the United States. According to U.S. District Judge Mame Iwusi Mensah Frimpong of Los Angeles, the Fourth Amendment stipulates that reasonable suspicion cannot be based solely on factors such as race, ethnicity, language, location, or employment, whether considered individually or collectively. This perspective was echoed by Ninth Circuit judges Marcia S. Berzon, Jennifer Sung, and Ronald M. Gould. The court's opinion emphasized that the individual plaintiffs do not need to take any specific action other than living their daily lives to potentially be subjected to the contested stops. Legal experts note that winning Fourth Amendment injunctions is challenging. Plaintiffs must not only demonstrate that they have been harmed, but also that they are likely to experience similar harm in the future. To satisfy this requirement in court, it is often necessary to show that the injury stems from a government policy. During a hearing on Monday, the appellate judges rigorously examined this issue, extending the administration's response time in their quest for clarity. Judge Berzon posed a critical question. After the district court's injunction, the Secretary of Homeland Security stated, "We are going to continue doing what we're doing." Is that not indicative of a policy? In response, Deputy Assistant Attorney General Yaakov Roth asserted, the policy is to adhere to the Fourth Amendment and to necessitate reasonable suspicion. Roth also dismissed inquiries regarding a previously mentioned quota of 3,000 arrests per day, which had been highlighted by White House Deputy Chief of Staff Stephen Miller in May. In a memo to the panel on Wednesday, Roth clarified that no such goal had been set. The court rejected this argument, stating that no official statement or explicit policy is necessary to establish that one exists. The opinion noted that agents have conducted numerous stops in the Los Angeles area over a few weeks, with some occurring repeatedly in the same locations, thus increasing the likelihood of future stops. The ruling criticized the Department of Justice for misinterpreting the restraining order it sought to overturn and for mischaracterizing Judge Frimpong's order. It also dismissed the government's primary assertion that its law enforcement activities would be chilled by the district court's ruling. The panel concluded, the defendants have not demonstrated that they will be chilled in their enforcement actions at all, much less in a way that constitutes the irreparable injury necessary to justify a stay pending appeal. Currently, the case is still in its early stages, with preliminary injunction hearings scheduled for September. However, the chaotic public arrests that began in Southern California on June 6 have largely diminished in the 7 counties affected by Frimpong's order: Los Angeles, Riverside, San Bernardino, Orange, Ventura, Santa Barbara, and San Luis Obispo. Mohammed Tajar from the ACLU of Southern California, part of a coalition of civil rights organizations and attorneys challenging the arrests of 3 immigrants and 2 U.S. citizens, remarked, "The fundamental principles of the Fourth Amendment are not complex. Even a more conservative panel would have raised concerns about the government's actions." Los Angeles Mayor Karen Bass, whose city was among several Southern California municipalities permitted to join the lawsuit this week, expressed her joy at a hastily organized news conference late Friday night at Getty House, her official residence in Windsor Square. With a determined smile, the mayor approached the gathered television cameras and declared, "This is a wonderful day for Los Angeles," framing the court's decision as a triumph for the Constitution and a reaffirmation of the rule of law. She added, "Upholding the temporary restraining order means that individuals cannot be forcibly taken off the streets by masked agents, as we experienced for nearly 2 months in the city," referring to the increasingly aggressive raids often executed by masked agents in unmarked vehicles. Bass, who has personal ties to the Latino community through her late husband and family, described the raids as profoundly personal. Speaking directly to the immigrant community, she expressed hope that the pervasive fear gripping local neighborhoods would begin to dissipate. "My message is that I hope this sense of fear will lessen, allowing people to emerge from their homes, return to work, and help our economy recover," Bass stated. The Trump administration has previously indicated its determination to challenge judicial restrictions on its deportation initiatives by any means necessary. It remains uncertain how the appeal process will unfold, but Bass speculated that the administration would likely seek to escalate the matter to the Supreme Court.